Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place. Did you know that any business owner is on average 7 months away from losing everything? That is the average time it takes from a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? Do you feel like there is a divide between lawyers and their clients? Then this TV show is for you. It is all about empowering you and your business with the knowledge and tools to ensure that this doesn't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show that will give you some actionable steps to consider for the week for your business. And at lunchtime on Wednesdays, we present our in-depth show of between 30 minutes and an hour, where we go through complicated legal aspects of your business in a simple to understand, plain English manner. And whether that is through educational pieces or interviews with experts in their fields.
Afternoon everyone, and welcome to another episode of Business Legal Lifecycle TV. I'm Craig Mason. I have with me Jeremy Stretton, one of the founders of the Business Legal Lifecycle and the author of the Business Legal Lifecycle book. Jeremy, say hello.
Hello everyone, hope you're having a great day.
Excellent. So today's Wednesday, so we're doing one of our longer form education shows, and it's in the month of July 2018, and so at the moment we're talking about estate planning and retirement. So, Jeremy, do you want to explain a little bit more about how that fits into the life cycle, where it sits, and a little bit of a summary about estate planning and retirement?
Yeah, absolutely. Thanks, Craig. So, for anyone who saw Monday's show, which was show 108, I did Fast Fix Monday. Craig was on holidays, and I did explain this, but I'm going to explain it again for those who didn't see it. And what's up on the screen now, if you're watching on Facebook, YouTube, or Periscope, and if you're not, if you're listening to the podcast, please go to businesslegallifecycle.com.au and you'll see a copy of the Business Legal Lifecycle. But what's up on the screen is Phase 8 and Phase 12 are circled. So the reason these are together is that they're very important and that they do go together, and it's very important that, that they're explained at the same time. So estate planning is all about wills, putting your power of attorneys in place, and basically putting the structure in place to make sure that if something happens to you, that your estate is protected. Retirement is really what happens after you sell the business. And you may choose not to retire, you may choose to go forward and go and start a new business. But retirement is all about making sure that what you've put in your estate plan is correct so that you can live the life that you want to live going forward. So so this month, July, as Craig said, is all about retirement and estate planning. And as Craig said, yeah, this longer form show, as we do at the beginning of every month, is an education show where we go through and explain some of the concepts from the certain phases so that you can have a better understanding about the business legal life cycle and how it might apply to you and your business. So without any further ado, I'll get into the first part, which is estate planning. And then Craig's going to talk about what happens if you die. I'm going to talk about buy-sell option agreements. Craig's going to talk about wills. Then I'm going to talk about power of attorneys. Craig's going to talk about advanced health directives. And then we're going to finish off with self-managed super funds and consultancy agreements. So starting off with estate planning. So estate planning is really the process that you go through. And it's something, the topic that you go through to really decide what's going to happen when you pass away. So what's going to happen to your estate when you pass away. Now, understandably, and I get this, it's not something that we like to think about as human beings. None of us like to think about what happens when we die. However, did you know that the longest running legal case in history was an estate planning dispute case? So it started back in 1798 and it didn't end until 1915, 117 years later. And it was all over the fact that the gentleman who had died was a very wealthy man, and he didn't leave a proper will in place. Now, obviously these days it'll probably happen a lot sooner, but a lot of money and a lot of heartache was caused to the family and to the estate And the only reason that dispute ended was because the estate ran out of money. So estate planning is very important to avoid those kind of problems going into the future. It's something that we at Business Legal Lifecycle and through our law firm, Stratton Masons, we're very passionate about getting people's estate plan correct because, whilst that's an extreme example, we've seen cases, just in our own careers, both Craig and I, where people have spent a lot of money in their estate because the person who passed away had lots of money but didn't put a will in place. So, in the ever-increasing litigious nature of our society, putting the right plan in place and telling your family and friends what you want to happen with your estate is becoming more and more important. As you're building a business and towards having a saleable position, you never know what might happen. So you need to make sure that what you want is documented and is documented properly so that you can make sure that your estate goes where you want to, and that your family and potentially friends aren't squabbling over it when something happens to you. So as I said, we're going to talk about different topics. Craig, do you want to add anything on estate planning, or do you want to jump into what happens if you die without a will?
I'll just jump straight in, Jeremy.
No worries.
If you want to bring up the next slide there. Excellent. So as it says, if you're watching this, what happens if you die? It's this slide. So essentially, if you don't have a will or any form of estate plan in place and you die, then your estate is governed by what's called the law of intestacy, which basically means you just don't have a will. Different countries, states in Australia, etc., have different rules about it, but essentially it's a fallback position where if someone doesn't have a will, then there's a strict set of rules that applies to that person's estate. So it's not that it just goes straight to the government, as some people sometimes think. There are steps and guides that need to be followed. And for instance, in Queensland, it might be that the first 150,000 and the household chattels goes to your spouse, and then after that, if you've got children, then it's split between your children and your spouse, depending on how many children you have. So there's different rules about that as to how it all works. The same with if you don't have a will, then you haven't appointed an executor. Therefore, your family have to apply normally to the court to be appointed as the executor or the administrator of the estate. They have to go through the process there, and there's more costs involved with those sorts of things than if it was that you had a will. So it's pretty important to have. So if you don't have it, then you're in the hands of whatever particular country you might be in. And the same goes with an interest in a business. If you die without having any form of business succession planning, estate planning in place, then your share in the business is going to be split according to, if you don't have a will at all, according to the rules of intestacy, which may not be the way that you want it to be. And even if it may be that you're going to have different family members involved now that have an ownership in a business when they really shouldn't be there, and it can cause a number of issues. So it's definitely something you need to sit down and talk to your consultants about, so your lawyer, financial planner, accountant, get all that sort of advice during the business life cycle, and they can help you, obviously guide you through the way forward to make sure you've got everything in place. It shouldn't necessarily be seen as a negative thing to do. Obviously dying, no one wants to die, but putting these things in place gives you comfort, peace of mind, and those sorts of things that it's all sorted out. And then if anything ever happens, you know that you've got things in place. So what happens when if you die and you don't have one? Essentially, all sorts of issues pop up, and costs will increase. So I think that's probably it for that side of it. Jeremy, do you want to move on to buy-sell option agreements?
Sounds good, Craig. Thank you. So buy-sell option agreements. These are something that a lot of people, it's a bit of a buzzword. People hear them, and a lot of people don't understand what they actually are. So I'm going to explain what they are, and I'm going to give you a bit of an idea about how they can be used. So a buy-sell option agreement is an agreement which is triggered upon your death or the death of your business partner, or your total and permanent disablement. And basically what it does is it triggers an option to sell the interest that that person has in the business, which is usually shares in a private company, to the other business owners. So ordinarily there will be a payment that is made to the family. Sometimes it's from an insurance policy, and it's designed to take the guesswork out of what happens to the business relationship, as Craig talked about, if one of the parties dies or becomes disabled. And it's also there to ensure that the business and the business partners can continue to operate the business and take control without having to, the family, who will no doubt be dealing with a very tragic set of circumstances, basically being able to do that properly and not have any arguments or not knowing what actually happens. So it takes the guesswork out of that. It also, has the advantage of that there are insurance policies that you can get that can actually be used to pay out family members so that they're receiving compensation and the business doesn't have to find the money. Because that can be one of the biggest things. If a business partner passes away and they're a major source of revenue for that business, then they may not be able to get the business that they and money that they need to be able to pay out their business partners. So insurance policy really does help that. So basically, they're great assistance where there's some unexpected incident that's sudden and unexpected. And really, you need to be really careful here. These are the kind of agreements that you have to get drafted by a competent lawyer who knows what they're talking about, because they are finicky. You need to make sure that the events are right, and that you got the right advice. You also need to get advice from your accountant and potentially financial planner. In fact, definitely financial planner, because financial planners have to give advice about insurance, and that advice needs to be around what insurance is best, what the best way to structure the payments are to get the best tax benefit for all the parties. So you need to involve all of your consultants. You need to make sure that they understand all the different parts of your business and how that's going to work, and that you understand it and that your family understands it, so that if you've got business partners and something happens to you, that the buy-sell option agreement is triggered properly, because it is a tricky little area. And doing it right, though, can mean that you can take a lot of the guesswork out of what happens if something happens to you or your business partner, and give you a lot of certainty going forward. So that's buy-sell option agreements. Craig, do you want to have a chat about wills?
Yeah, absolutely. As Jeremy just touched on, all these sorts of things, putting these documents in place, as I said, can have a negative connotation, but getting it all sorted out, talking to your consultants, gives you peace of mind, knowing that something ever happens, you're going to have these things in place that are going to help your family going forward. So, and one of those is obviously a will, and having a will in place. The sorts of things you need to think about, obviously the executor, so that's the person that you appoint that basically follows the will and administers the estate. So you need to pick someone that you think can undertake those tasks, because some of them can be onerous, I guess, and time consuming. So obviously, again, an executor would be talking to consultants and getting accountants and lawyers involved. But the other sorts of things that you need to consider when you're doing a will, everyone's circumstances are different. But if there's blended families, you need to think about that, where you might be remarried and both parties have children to different relationships. There might be estranged family members. So you need to be careful if you're ever not including a child, for instance, in a will. You need to make sure that you're getting the right advice about that, because excluding people from wills, as Jeremy touched on before, with our litigious society, there's a lot of litigation regarding what's called in Queensland, at least in Australia, is family provision, which is essentially where you're saying as a beneficiary that you've been left out of the will and you have a real need or dependence on the person that passed away, and you need to be given more or something out of the estate. So if you're not going to include someone, you need to be careful about how the will is drafted, and make sure that it's clear that you're not just forgetting about someone, that you're actively not providing for them. So there's sorts of things you need to consider. Obviously, as part of that, they're the beneficiaries, but you also need to consider your actual estate. And these are things, you would have seen your accountant along the way during the business legal life cycle of the business. and you've probably got other asset protection things in place, discretionary trusts, those sorts of things that might be running your business back in phase 2 or 3 of the life cycle. So you've got to make sure that all of those fit into what you're doing with your will as well, because you can't gift someone something from a discretionary trust, for instance, because that's a separate structure. This is most of the time this is things that are in your own name, so shares, property, those sorts of things that are in your own name. You also might have to appoint or want to appoint directors and those sorts of things to companies. So you've got to consider all of your assets when you're drafting a will. Also, what flows from that in terms of asset protection is what's called a testamentary trust. So testamentary trust is essentially a will with a discretionary trust tacked on to the end of it. And the trust doesn't actually come into existence until you pass away. And so instead of your estate going to the beneficiaries, say you had $400,000 and you were giving it to your 4 children and they were over the age of 18, normally if you just had a standard will, they would get $100,000 each and they could do what they wanted with it. In terms of a testamentary trust, what you would do is you'd establish a trust for the 4 children, and the $100,000 would go into a trust for each of those. They might be the trustee, you might have someone else as the trustee, and that then protects that $100,000 from any attack against one of the beneficiaries. So essentially it's providing asset protection to your beneficiaries going forward. It has no use or protection whilst you're alive to any of your assets, but it protects them going forward for your beneficiaries. So most of the time you can consider it if you've got adult children and they're in an occupation or have their own business or something along those lines where they're at risk of being sued. You might want to consider it then, because it would be quarantined from any bankruptcy trustee or any creditors. Family law might be another reason to consider it. Won't necessarily, can't defeat a family law property settlement, but it can, it's taken into account, but it's not necessarily able to be divided between the parties, but it's taken into account. The family law court can look behind those sorts of things in Australia at least. But it does go some way to protecting those sorts of things. And there are some tax benefits as well, but and that's what you'd speak to your accountant about. So you can have your standard type will, and then you can have the testamentary trust, which is basically a will with a discretionary trust attached to it. So it's definitely something to consider, particularly as, we're talking about life insurance and those sorts of things with Jeremy in the last slide. People's estates these days are worth a lot more than what they probably used to be. Life insurance, it's not uncommon for people to have life insurance policies of $1 million, $2 million. And if that's going back into the estate, then the beneficiaries are, potentially getting a large sum of money. So that's when you need to consider testamentary trusts, think about your beneficiaries, those sorts of things. If you've got minor children, then you're going to be thinking about guardians and all those sort of trustees for those children, because you want someone that's responsible, obviously, and is going to make the right decisions for your children if both you and your spouse passed away. So definitely not something that you just, we wouldn't recommend going to the post office and doing your take-home will kit in this instance. It does have, it's better than nothing, I guess, but you've really got to sit down with your consultants at this stage of the business. You've grown your business. Your business is probably worth quite a lot, and as part of that, you've used that money, invested it, bought property, and those sorts of things. So you've got a sizable estate that you need to try to protect and make sure it goes where you want it to go. And in order to do that, you're definitely going to have to sit down and draft up a will. And use your consultants, your accountant, your financial planners, and your lawyer to make sure it's going to go the way that you want it to go. Same goes with superannuation, which we'll talk about a bit later in terms of self-managed super funds. But if you don't have a self-managed super fund and you have an industry fund or a retail fund or whatever it might be, then you need to have a look at that and consider that as well. Go through the binding nomination process, make sure that your super is flowing to where it should go. Again, seeking the advice of your accountant in terms of the tax benefits for either going to the estate or going to the dependents. But you've just got to sit down, get all the information together and go through that process. As I said, dying is not a great thing, but getting it all sorted gives you some peace of mind and allows you to tick that one off the checklist and move along in the rest of your business. So, yeah, that's wills. Jeremy, do you want to talk about what's sometimes described as a living will, a power of attorney?
Absolutely. Thanks, Craig. So, yeah, as Craig said, sometimes power of attorneys can be called living wills. And a power of attorney is a document that gives another person the power to make decisions and sign documents on your behalf. So you need to be really careful about who you give these type of documents and powers to. There are two different types of power of attorneys that I'll discuss. The first is a general power of attorney, which you've probably heard of, and the second is an enduring power of attorney. So I'll go through those. But you should know that each of the different states in Australia, and this would be the same in the US and the UK, have different rules about how to actually put together a power of attorney. And so you've got to be really careful that a power of attorney that may be drafted, say, in Queensland and signed in New South Wales, you've got to be really careful to make sure that actually is binding, because it may not be. There are different rules in different states and different rules about where things can be signed and all the rest of it. So make sure that you get advice. Make sure you get a local power of attorney signed and that you've got advice to make sure that it's actually valid and binding. So as I said, there are two types. The first is a general power of attorney. So any entity, so including an individual, a person, a company, a trust, a partnership, can give a general power of attorney to another person or another entity to sign on its behalf. The general power of attorney is a document that usually gives a power to sign, that you usually give someone when that person's overseas. For example, if you're going overseas and you had a trusted friend or advisor and you had a large property transaction coming up, and this happens all the time, you might appoint your lawyer to actually, or the trusted friend or advisor, to sign documents on your behalf. They're usually terminated pretty shortly thereafter, so that if you come back, then the power of attorney still survives. So it can be useful, so that you're not trying to get documents signed when people aren't around. So that's when they use a general power of attorney. An enduring power of attorney is different. It's a stronger document, and basically the main difference between a general power of attorney and an enduring power of attorney is that if you lose capacity, a general power of attorney ceases to actually be able to be used. An enduring power of attorney continues. I should say too that both forms of power of attorney cease to be able to be used once the person dies. That's a common misconception that people have. So once you pass away, you can't. The person who you've given a power of attorney to can no longer use that power of attorney. The will, as Craig talked about, then applies. So enduring power of attorney gives the power to make decisions for health, for financial decisions. And basically, you need to be really careful about who you give an enduring power of attorney to, because once you lose capacity, you may never get it back, and so you may never be able to revoke it. So you make sure that you give it to someone that you trust. Usually, an enduring power of attorney is given to a husband or wife to each other, so that they can make decisions. Another common misconception is that if I'm a director of a company, which I am, of several companies, my enduring power of attorney does not work to give power to my attorney to make decisions on my behalf as a director of those companies. The company would have to give that power. So there's a lot of tricky bits and pieces of power of attorneys, a lot of misunderstandings that people have. So if you do need to give a power of attorney, make sure that you get advice. Make sure you talk to your lawyer or your advisors to make sure that what you're giving is right, and that if you need to revoke it, that you can. Craig, did you want to add anything onto the power of attorney? I think I covered everything.
Yeah, no, absolutely.
Cool. Do you want to move on to advanced health directives?
Yeah. All right. So advanced health directives. This is something that concerns health decisions. So as Jeremy touched on with enduring powers of attorney, it's for financial and it's also for personal and health. So you're appointing someone if you lost capacity, they can make health decisions on your behalf. Advanced health directive goes further to that. So it's rather than just appointing someone that can make those decisions, it's actually going through a number of questions about certain medical conditions that you might suffer from, and basically give an answer as to what you would like to happen if you're suffering from that condition. So obviously, in this instance, you're not talking to your accountant, financial planner, or a lawyer. You're talking to a doctor, because they're going to explain the actual medical conditions to you in medical terminology, and say, if you were suffering from such and such, you want this to happen, and then you tick yes, no, or whatever. So you've got to go and see a doctor. There's a number of questions, and it essentially takes it out of the hands of the attorney under the power of attorney, and if the doctor, if something ever happened to you and you're in hospital, is then following the list of the questions in the Advanced Health Directive. So it's definitely not for everyone. It's more common if you've seen someone, a loved one, pass away, and you know they didn't want that to happen to them, etc., that you'd be thinking about doing it. As I said, you do need to go and see a doctor, have a consultation and go through a number of questions. Then the doctor signs off on it to say that you've understood it all, etc., and then it becomes an Advanced Health Directive. As part of the document, at least in Queensland and most states in Australia, there is part of that is also appointing an attorney in the Advanced Health Directive. You just need to be careful if you are ever looking at it that it's you're not appointing another power of attorney in your Advanced Health Directive that contradicts the power of attorney that you've done separately, because once you do a new power of attorney or a new Advanced Health Directive or a new will, most of the time that's going to revoke any previous documents that you have signed. So that's something that you need to consider when you're doing the Advanced Health Directive. As I said, it's not for everyone. Get the right advice. You've got to go and see a doctor. It can be a confronting process because they are going to be explaining some, different medical conditions, but definitely something you need to consider during the estate planning process. A document that you may want to get in as part of that is the Advanced Health Directive. But Jeremy, if you want to move on to self-managed super funds.
Yep, self-managed super funds. So in 1992, the Australian federal government introduced compulsory super for all employees in businesses. So this mandated that all employers were to take a proportion of their employees' wages and pay it to a superannuation fund that could not be accessed until the person reached certain conditions, including a retirement age. So most people in Australia have a superannuation fund. There are, in the US, I know there's 401ks that they're called, but most people in Australia have a superannuation fund that's either a retail or an industry super fund. So these are large institutions that manage superannuation money on behalf of the individuals who are members of the fund. They are paid a fee, usually based on a percentage of the money that they manage, and they basically put all the money together and manage the superannuation for people to try and build their nest egg, and it's like forced savings for people for employees. As long as there's been superannuation, there's been the ability to have your own self-managed superannuation fund. It's very similar, a self-managed super fund, to a trust. So if you're interested in hearing more about trusts, if you go back to show 3, so if you go back to businesslegallifecycle.com.au/003, Craig and I go through in the third show, one of the very early ones, we go through the different structures, and trust is one of those. But it basically, it's a fixed trust. It has a trustee, and they have the day-to-day control over the fund. It has members who are the beneficiaries, and they own their shares in the self-managed super fund as a proportion of what they've contributed to the self-managed super fund, which is their wages over a period of time. That's just the simplest way to think of a self-managed superannuation fund. There are a lot of rules about self-managed super funds. For instance, you can't access the money. People do that. It's a no-no. You can get into a lot of trouble. You can lose your self-managed super fund if you try and access the money. But you need to be really careful that you comply with the rules. You've got to have an audit done every year. One of the main misconceptions with a self-managed super fund is around who should be the trustee. So if you remember when we've talked about it previously, and as I said in show 3 and in other shows, when you have a trust, the trustee of the trust is primarily liable for the debts of the trust. They are just entitled to be indemnified out of the trust assets. So what does that mean in plain English? That means that if you're the trustee of your own trust, you incur a debt, you're liable for that debt. If the trust doesn't have the money to pay for it, too bad. You've still got to stump up the cash. So what you've got to do is set up a self-managed super fund with a company trustee. That protects you as an individual, so that if there are debts that the trust incurs that can't be paid for whatever reason, and you don't want that to occur. But again, as lawyers, we're always looking at the worst case scenario. Then you're not personally liable for it. The other reason to do it is that if you pass away, having individual trustees of a self-managed super fund can be very difficult to change. And goes through a whole process because it's not as easy as just changing the directors in a company. So there's lots of reasons to do it like that. Self-managed super funds can be used for all sorts of investments. They can own shares, property, they can own interest in certain companies. However, I said there are very strict and complicated rules about what you can and can't use your money for. For instance, you can't usually invest in your own business with your superannuation money. You can't purchase a house that you're going to live in, but you can purchase an investment property. You cannot loan money from the self-managed super fund to yourself and to use for any purpose. So they're set up, to save for people's retirement, and so these rules are in place to try and make sure that people who use self-managed super funds don't use it for their own personal use until they retire. So, as I said, you can use it to buy property. You can also borrow money under the right circumstances. There's a whole structure that you need to set up where you might have heard the terms bear trusts, and you can buy property and shares with a self-managed super fund if you set the trust up properly. Get advice with that though. Get advice from your lawyer, get advice from your financial planner, get advice from your accountant, because they are complicated structures and you've got to get them right. Because again, if you don't, then you can really struggle with your business, and you can get into a lot of trouble with the Australian government, the ATO, and the regulators of self-managed super funds, because they are complicated rules that you need to make sure that you get right. So using a self-managed super fund can be of great benefit. What a lot of people do, and it works, is to use self-managed super funds to buy the property that they run their business from. Obviously, you've got to be careful there not to put all your eggs in one basket. You've got to be careful not to have all of your money tied up in one asset, because if the business fails, and again, we don't want that to happen, but it might, then you could get into a lot of trouble, and you could lose all of your money and lose everything going forward. So self-managed super funds, they're really important things to get right. They're really important things to make sure that you understand. But if done correctly, they can be of great advantage to your business. Craig, do you want to finish off with retirement and consultancy agreements?
Yeah, absolutely. So as part of today's show, I just wanted to touch on retirement, and as part of that, consultancy agreements. Obviously, you've built your business up and you're at that stage where hopefully it's a saleable asset and you're selling your business as part of your retirement strategy. Sometimes when you're doing that, you may be requested or required as part of the sale to continue to work in the business for a period of time. That's where the consultancy agreement comes into play. So there might be a number of reasons as to why you may be doing this. One could be that you want to help the buyer essentially find their feet in your old business. It might be a condition of the actual sale contract that you work in there for a period of time, or it also might be a condition that there's future payments that are going to be paid to you if there's certain financial goals that the business reaches once you've retired but working in the consultancy stage. So they're the sort of main sort of reasons as to why there might be a consultant agreement in place. So obviously there's different consequences for the different types of reasons why you might want to consider working in the business. We'd suggest anyone that's thinking about doing it, it's not just a take it lightly decision. You really need to think about it because there are, and the same goes for the buyer. There are some problems potentially in the future with having someone in the business that has essentially exited. And they might be exiting in terms of not really doing much in the business and just showing up as per the agreement but not doing a great deal. So you've really got to think about those sorts of things. So when you're, if one of the reasons is that you want to help out the buyer, then, you've obviously got to be certain that the buyer actually wants you to be there. As I said, having someone there that was basically the face of the business and then they're sticking around to sort of help someone out. You've got to be very careful that it's, not going to be at a disadvantage to the business going forward. So at this stage, you want to be explaining to all the employees that, what that person's role is going to be, and those sorts of things. And that's one of the main things you've got to think about when you're doing the consultancy agreements, is the actual duties and responsibilities of the person that's sticking around. So as I said, a lot of the times it might be part of the contract for the business owner to stick around, and that's not that uncommon for that to happen. There could be some training, whatever it might be. They mightn't have any experience in the business as well, so they need someone there to basically show them what they need to do, etc. So you want to make sure that there's a term put on that as to how long it's going to be. And then again, you've got to be clear as to what the actual business owner that's exiting the business is actually going to be responsible for, etc., etc. So one of the other ones where there's some issues is where the condition on future profits of the business for a larger payout. So you might be, purchase price must be 500,000, but that's contingent upon profits increasing or staying the same for a period of time. So that's something you've really got to sit down and think about from both sides. Obviously, as the seller, you don't know what's going to happen in 12 months' time. There could be, all sorts of things that have affected the business that was outside of your control. That's going to influence the payout that you might be receiving. So you've really got to sit down and talk to your consultants about that before agreeing to those sorts of things in the sale. So they're the main sort of reasons as to why this would happen. In terms of what should be in the consultancy agreement, as I said, it's really important to have the duties in there. So this is what the seller is responsible for doing, and make sure that that's communicated to everyone, so they're on the same page. And I'm talking about employees and other people in the business. Obviously, you want to work out what the actual remuneration for that person is going to be. It's going to be a wage or whatever other structure it is, but you want to make sure that there's a figure and it's not open-ended. You want to have a term on this, so how long it's actually going to go for. Is it a month, 3 months, 5 years, whatever it might be, but there needs to be some form of term in there. If there's any expenses, who's responsible for those, who's going to be reimbursed, those sorts of things. And other sort of general conditions as well in a consultancy agreement about confidential information and those sorts of things are going to be in there. And if there's any rewards or goals that need to be reached, all those sorts of things need to go in the consultancy agreement. So everyone's on the same page and knows exactly what they need to do to reach the particular goals, what their duties are, and then hopefully, there shouldn't be any problems going forward if everyone documents it. And that's what we say a lot during our shows, is about making sure that you have documents. You might all be friendly, on a handshake, those sorts of things, but if you have an agreement in place, at least you can fall back on that if there's any issues in the future. So that's what we wanted to talk about in terms of retirement and consultancy agreements for today's show. Jeremy, did you want to add anything or wrap it up for today?
Yeah, no, nothing to add. I think that's a great explanation. I think, you just got to be really careful, as you said, with consultancy agreements, that they're documented properly and that you understand your roles and responsibilities, because we've seen it far too often where people have failed and it's become a massive fight where if the people just communicated it at the beginning, it wouldn't have happened that way. So look, I hope everyone's enjoyed today's show. Please remember to like this show on Facebook if you're watching us on Facebook. Like our page if you haven't before, Business Legal Lifecycle Worldwide. If you're interested in the show notes, businesslegallifecycle.com.au/109 for our 109th show. There's a copy of the workbook in the Facebook. I've put that there as a comment. And you'll be able to download it from the show notes page as well. So we'll be back next week on Monday with Fast Fix Monday with more about phases 8 and 12. Thanks very much for joining us and have a great day.
Thanks everyone. Bye.